Hello, my name is Stephen Spittlehouse. I'm the Merits Tech Lead and I'm based in the South Tyneside office of the Legal Aid Agency. This part of the presentation is relating to the information that should be uploaded when you're submitting an application or amendment that will help us grant a certificate the first time of asking. In relation to domestic abuse applications, for the applicant, we need a statement that sets out the history of the matter and the previous incidents, together with the most recent incident that has led to the application. If there's been a delay in seeking injunction, so for example, the application has been made several weeks after the last incident, explain why there has been a delay and why you consider the court will still make an order. We need you to address the question of proportionality. So you'll need to explain why alternatives such as sending a warning letter or notifying the police are not appropriate. We need you to set out the involvement of the police, and if they are providing support such as bail, you need to explain why the bail protection is inadequate and why the client separately requires a protective injunction. It's okay to submit with your application a statement that you send into the court in support of the application for the injunction. If you do submit that statement, we still need to confirm if a warning letter has been sent and of any police involvement. You can do that in a merits report or submit a separate statement. If you're acting for the respondent, please set out a detailed response to the allegations. A blanket denial is insufficient. Any effect an order will have on other matters between the parties, so for example, child arrangements, and while the matter cannot be settled by way of an undertaking. We would also preferably a copy of the opponent's application. Moving on to private law applications, such as Section 8 applications or financial proceedings, ensure you have the relevant domestic abuse or child protection evidence to bring the proceedings into scope when you submit the application. If you're acting for the applicant in the proceedings, upload any correspondence with the other side or their solicitors with a view to settling matters. If no correspondence has been sent, please explain the reasons why. It may be the client is a victim of domestic violence, meaning they can't negotiate with the other side, but that shouldn't prevent the solicitors from doing so on the client's behalf. If you're acting for the respondent, provide us with the application made by the applicant, any orders made to date, and any expert or CAFCAS report if applicable. In financial proceedings, we need you to set out the details of the assets in dispute. In trusts of land proceedings, you'll have to tell us how the client has acquired an interest in the property. For all cases, we need you to set out the circumstances of the case, the issues that are in dispute, and any steps taken to reach a settlement. Moving on to public law children matters. In special children act proceedings, if applications that would normally be private law matters, so for example, residence or special guardianship order, are being heard within care and supervision proceedings, then those proceedings can be added to the certificate as related proceedings, and there are appropriate proceeding descriptions under the SAA matter type. If your client is seeking to be joined as a party in care proceedings, we need a statement setting out the client's involvement in a child's life and what role they seek to play in the future. We would need copies of any assessments of the clients, and if there have been any negative assessments towards a client, you'll have to explain the basis on which the report conclusions are to be challenged. If the client is seeking discharge of care order, you need to set out the changes that have been made since the original order was made, as well as any approach that has been made to the local authority, and set out the basis upon which you seek to persuade the court a care order is no longer required. If seeking contact with the child in care, set out what approach has been made to the local authority and how contact has progressed to date. In appeal proceedings, where you're appealing an order, if you are representing the appellant, please upload a copy of the court order and a transcript of the judgment, or If a transcript of judgment is not available, counsel's or solicitor's written note of the judgment. We also need a grounds of appeal or a statement setting out the basis the decision is flawed. If all you seek is an opinion from counsel, we still need you to provide us with an indication as to the grounds of appeal. Simply stating that you require counsel to advise will not be sufficient to enable us to determine the merits test, so we'll probably go back and ask for more information. If you are representing a respondent, provide us with a copy of the application made to the court and a statement setting out the basis upon which the other side is pursuing the appeal, as well as provide any orders made to date. Please note, though, that an interim appeal does not require an amendment to the certificate either for the appellant or respondent, and an interim appeal will be covered by the existing scope on the certificate, subject to that scope covering the certificate for the work that's resulted in the appeal. We'll now move on to amendments to existing certificates. If you're seeking an amendment to add new proceedings, provide us with a statement setting out the circumstances of the case and issues in dispute, any steps taken to reach a settlement, any expert or CAFCAS report, if applicable. If you're acting for a respondent, provide us with a copy of the application made by the other side, any orders made to date, and if adding financial proceedings, details of the assets in dispute. If not supplied previously, we will require the domestic abuse or child protection evidence you're relying on to bring the proceedings into scope. If you're seeking an amendment to cover the final hearing, we need the court order listing the hearing, as well as the parties' position statements or a statement setting out the issues in dispute, and copies of any expert reports such as CAFCAS or Section 7 reports. If you're seeking an amendment to the cost limitation, provide us with a breakdown of the costs incurred to date and an estimate of costs to be incurred and the work required to justify those costs. That is this section covered, so I'll pass you to my colleague Peter Reid.
Hello everyone, my name's Peter Reid. I'm also one of the technical merits leads based in the South Tyneside office, and I'll be taking you through the slides covering a brief outline of the evidential requirements needed to bring certain proceedings into scope for legal aid. So just to give an overview, first of all, the requirement for supporting evidence is contained in paragraphs 12 and 13 of Schedule 1, Part 1 LASPO, and it is not a requirement for legal services provided under paragraph 10 of Schedule 1, Part 1, which relate to unlawful removal of children. And there is a set of guidance in the Lord Chancellor's guidance setting out the circumstances where we consider it to be an unlawful removal. Supporting evidence is not required for applications submitted by children, clients under the age of 18, or in any private law special guardianship applications. They no longer require supporting evidence to bring them into scope. We have detailed guidance available on the types of evidence that will be accepted in the evidence requirements for private law family matters. That document's contained on the gov.uk website on the legal aid pages, and there is also a link to that guidance in the slides at the end of the pack. And while it's not a prerequisite for evidence to be dated, because there is no formal time limit on evidence anymore, it is a requirement in circumstances where funding has been granted using delegated functions, because we need to know that you had the necessary evidence to bring the proceedings into scope before you exercised your delegated functions. If you did not have the evidence, that use of delegated functions would be treated as ultra vires and would be disregarded. So moving on to the proceedings for which domestic abuse evidence can be relied on. There is a full list of the family enactments which are brought into scope using domestic abuse evidence at the end of paragraph 12 of Schedule 1, Part 1, and they are also listed in Schedule 1 to Procedure Regulation 33. And you'll see that it's a wide range of family enactments covering both private law children and private law financial matters, including divorce, dissolution of a civil partnership and nullity proceedings. Basically, any of those proceedings can be brought into scope by way of domestic abuse evidence. Moving on to those proceedings which can specifically be brought into scope purely on the basis of child protection evidence, you'll see from the slide that it is a much more restricted list of cases. It's restricted purely to child arrangements orders in relation to where the child will live or who they will spend time with. Applications under the Children Act for the removal of a father's parental responsibility. Applications for specific issue or prohibited steps orders, and applications under Section 33 or 34 of the Family Law Act for disclosure of a child's whereabouts or for the return of that child. So it's a much more restrictive list in terms of proceedings that can be brought back into scope using child abuse evidence. Looking in a little more detail at some of the more common types of evidence that we see provided and ones which cause both the agency and providers more in the way of difficulties. There are template letters produced and are available on the gov.uk website. There is a link in the evidential requirements guidance to take you through to the template letter page. And where possible, if you can encourage organisations that you are having contact with to provide that supporting evidence in the form of the template letters, and just as importantly, not to alter the terms of those template letters. And if we can also ask you before uploading that evidence, you check that it does contain all of the required information and that the format of the template has not been altered. Now, two of the most common pieces of evidence that we have problems with are letters or reports from an appropriate health professional. And issues that we have with these letters is that the evidence must confirm not only that it is considered that the client is a victim of domestic abuse, but also that they are suffering from an injury or condition that is consistent with being such a victim of domestic abuse. Quite often we see letters that simply say the client reports they are a victim of domestic abuse, or I consider the client as a victim of domestic abuse, without specifically identifying an injury or condition. And if that happens, unfortunately, the letter will not be acceptable. We also have several issues with letters from organisations providing domestic violence support services. Now, those letters also have to contain an expression of reasonable professional judgment that the client is a victim of domestic abuse. But in support of that judgment, they have to supply a description of the specific matters relied upon to support that judgment. They have to provide a description of the support provided and a statement of the reasons why the client needed that support. Now, we frequently find difficulties with the description of specific matters relied upon are simply not specific enough. So, for example, if a letter is submitted which simply says the specific matters relied upon are disclosures made by the client, that will not be sufficiently specific for our purposes, and we do need something more than that, setting out how the Domestic Violence Support Service has arrived at the conclusion that the client is a victim of domestic abuse. We also need to see a description of the support provided, so what help the DVSS has provided to the client, and we also need a statement of the reasons why the client needed that support. Now, we try to be as purposive as possible and take a purposive interpretation of these requirements. So if there is sufficient detail in the specific matters relied upon to support the judgment, we can sometimes use that to effectively double up as a statement of the reasons why the client needed that support. But if there isn't sufficient detail in the specific matters, then we do need that statement to spell out why the client needed support. Having said previously that supporting evidence does not have any time limits any longer, there are two elements of the evidence that are time sensitive still, and they are where there has been an arrest for a relevant domestic violence or child protection offence, and where there are ongoing criminal proceedings brought in relation to those offences. Where the perpetrator has been arrested for a relevant offence, we need to know that the investigation into that offence is still ongoing at the point at which the application is submitted. If the perpetrator was arrested 6 months ago and the case has subsequently been had no further action taken on it by the police, that will not be sufficient evidence because there is not an investigation ongoing at the point at which the application is submitted. Similarly, if charges have been brought and there are ongoing criminal proceedings, we need to know whether or not those proceedings have concluded. If they have not at the point at which the application is submitted, that's fine, that will be acceptable, but you will need to keep us informed as to the outcome of those proceedings, because if, for example, the perpetrator is acquitted, or if the charges are dropped, that will no longer be valid evidence to bring the proceedings into scope, and it will be necessary to provide alternative evidence in the event of an acquittal. We do sometimes see that several items of evidence are uploaded, and it can therefore be useful if you can identify which particular paragraph of the evidential requirements you consider a particular document satisfies. And if you are relying on evidence of child abuse to bring proceedings into scope, this brings with it a two-limbed test, in that the evidence must show that the child is at risk from a party other than your client, and also that the order that your client is seeking to obtain or to defend will have the effect of removing or reducing the risk to that child. So, for example, an application for a change of residence from the other party to your client would remove or reduce the risk identified to the child. But an application for contact by your client, where the child is going to remain with the person who has been identified as the risk, that would not be considered sufficient to reduce the or remove the risk shown to the child, because they would still be living with that parent who has been identified as the risk. That brings me to an end of the section on supporting evidence, so I'll now hand you back to Stephen.
Thank you, Peter. This next section will deal with delegated functions. Applications for emergency legal aid must satisfy the Interest of Justice Test Act Merits Regulation 46B. So, do the services sought need to be provided before there will be time for the legal aid agency to make a determination on substantive application? and what is the seriousness of the consequences of those services not being made available on an emergency basis. More details regarding this can be found at paragraph 727 to 729 of the Lord Chancellor's guidance. Applications can be submitted under the single or dual stage process. The dual stage or the two-step process is where the emergency application is submitted first, and once granted, the substantive amendment is then submitted. The single stage or the one step is where the emergency and substantive elements are submitted together. If you submit a non-delegated functions emergency, rather than using delegated functions, and where you can use delegated functions, please explain why delegated functions have not been used. In all cases, unless there's an issue with the client's means assessment, and you see paragraphs 5.6 and 5.7 of the standard civil contract, if you can use delegated functions, we would expect you to do so. If necessary, when you submit an application, amend the default limitations and add appropriate limitations to both the emergency and substantive applications. If the limitation isn't appropriate or has been omitted from a substantive application, we will add an appropriate limitation to the certificates. If you're delegating for a higher cost limit than the default £2,250, we need you to include reasons for the increased limit in the statements section of the CCMS merits report. In family applications, you can delegate for an injunction and children proceedings at the same time, relying on injunction to bring children matters into scope, as long as the applications are made and orders are obtained at the same time. So for any application where you're relying on an injunction and children proceedings, please upload copies of the applications and the orders obtained. That is this section covered, so I will hand you back to Peter.
Thanks, Stephen. I will now take you through another section, this time dealing with adoption, placement and special guardianship orders. So, looking at adoption and placement applications to begin with, for the purposes of the family fee scheme, all applications for adoption are considered to be public law matters and therefore must be submitted under the public law family matter type. And this is the case even if the adoption arises in what would ostensibly be a private law scenario, such as a parent, step-parent adoption. Now, we quite often get the situation where applications for placement are being heard within care proceedings, where the local authority has decided at an early stage that the only reasonable option for the child in these proceedings is that they should be placed for adoption. If that is the case and your client already has a certificate for care proceedings, that existing certificate can and should be amended. They will be treated as related proceedings for the purposes of Special Children Act certificates, and there is a specific wording for placement proceedings in the Special Children Act matter type. However, if the placement application is being made by the local authority after a final care order has been made, then a fresh application for legal aid will have to be submitted because the care certificate will have come to an end on the making of the final care order. In relation to adoption and placement, parents and those people with parental responsibility for a child who is subject to the placement or adoption proceedings, and where the client is opposing those orders, they are non-means tested and have a significantly reduced merits test. It's basically the reasonableness test contained in Regulation 66 of the Civil Legal Aid Merits Criteria Regulations. So if you are representing a parent or someone with parental responsibility in those proceedings and they are opposing the order, there is a set wording description to be selected in the drop-down list, which refers to either placement order, parent/PR, or adoption order, parent/PR. There are no related proceedings provisions in relation to parental placement or parental adoption cases, and therefore other proceedings such as discharge of a care order must be submitted on a separate means and merits tested basis. So unlike Special Children Act, there is no concept of related proceedings that can then be added to the non-means tested certificate. The children subject to the adoption or placement proceedings and any other parties involved in the case who are not parents or who do not have parental responsibility or who do not oppose the making of the order need to submit a means and merits tested application using the standard placement order public law family wording or application for adoption public law family wording. Please note, do not use the proceeding in the drop-down list entitled Contested Adoption Application Public Law FAM, because the full wording of that description specifically refers to the Family Proceedings Court, which you'll be aware no longer exists. So to avoid having an application rejected for an incorrect wording having been used, please don't use that contested adoption application wording. Moving on to special guardianship orders. Funding for SGOs is available both in private and public law matters in the following circumstances. A parental guardianship case is defined as an application made by a parent or those with parental responsibility for the child who are opposing an order for special guardianship or seeking to discharge an existing special guardianship order, and they are non-means tested and have a limited merits test. Non-parental guardianship cases are those made by the potential special guardian themselves, the child subject to the proceedings, and any other parties or parents or those with parental responsibility who are not opposing the making of the order, or a special guardian who already has an order in their favour and is opposing an application to discharge that special guardianship order. Those proceedings are means tested and subject to the usual merits test. If the special guardianship application arises in private law proceedings, there is no longer a requirement for gateway evidence to bring those proceedings into scope, and that is irrespective of whether it is a parental or non-parental guardianship case. There is no longer a requirement for gateway evidence in special guardianship proceedings. Where you are acting for a parent or someone with parental responsibility, those certificates can only cover the special guardianship order proceedings, but contact, representation on contact is automatically included. Once again, there is no provision for related proceedings in the same way as Special Children Act. So any other proceedings, such as residence, must be subject to a separate means and merits tested application and will need gateway evidence to bring those proceedings into scope. And any application to represent a non-parental party in special guardianship order proceedings, those applications are all means and merits tested. They can be amended to include other proceedings such as residence, but those other proceedings will need gateway evidence to bring them into scope. Once again, contact is automatically included as part of the consideration given by the court to the special guardianship element. Unfortunately, there are currently no relevant proceeding codes in our CCMS computer system to vary or discharge a special guardianship order. So in order to cover an application to vary such an order, you would need to apply using the relevant special guardianship order proceeding code set out above on the slide. But then you should select a non-standard hearing limitation and free type in the relevant wording to refer to it being an application to vary or discharge the special guardianship order in the merits report in CCMS. Moving on to applications made within public law proceedings. Again, at the current time, there is no specific wording dealing with a parental party proceeding under the public law matter type. So all parental party cases have to be submitted as private law using the above proceeding wording. For non-parental guardianship cases, the following proceeding code should be used. That is special guardianship order, public law family, or vary/discharge of a special guardianship order, again in the public law family matter type. If the special guardianship order is being applied for within existing care proceedings and the client has a Special Children Act certificate, then that certificate can be amended as related proceedings to cover the application for the special guardianship order. That brings me to the end of the section on adoption, placement and special guardianship. So I'll hand you back to Stephen again.
Thank you, Peter. This section will now deal with committal applications. Any proceeding where the client's liberty is at stake are defined as criminal proceedings by Regulation 9V of the Criminal Legal Aid General Regulations 2013. And all representation of respondents to committal and civil proceedings is remunerated as a criminal matter. This has been confirmed by the High Court in the case of Kings Lynn and West Norfolk versus Bunning, and then by the Court of Appeal in the case of Brown versus London Borough of Haringey. Therefore, if you want to represent your client as respondent in committal proceedings, you have to apply to the National Courts team in Nottingham on a CRM 14 form for authority to represent the client at the committal hearing. If you don't have a criminal contract, you'll have to apply for an exceptional case contract to allow you to act. If you're acting for the applicant who is seeking to commit the other side for a breach of an order, then that is a civil matter and an application can be made for legal aid, or you can seek to amend an existing life certificate. We would need the following information to consider any application. So we need details of the breach, any correspondence sent to the other side regarding the breach, such as warning letters, and details of any police involvement. That concludes that section. I will now pass you back to Peter.
Okay, and I'll now take you through the last section on the slides, just a couple of slides covering hints and tips on various matters that will assist you and us to deal with applications first time and avoid unnecessary rejections or refusals. Firstly, some things to be aware of about our computer system. Certain matter types can't be included on the same certificate. So public law family proceedings can't be added to a certificate that's been issued for private law matters and vice versa. High Court proceedings can't be added to a certificate issued for public law matters. You can add High Court to a private law certificate, but not to a public law certificate. However, we are aware that because of the way certain cases are handled or timetabled by the court, it is sometimes necessary for there to be this sort of crossover. And therefore, the only way you can add the appropriate cover to your existing certificate is by way of adding an additional scope limitation. So if you have a public law certificate where the local authority then makes an application for an order under the inherent jurisdiction of the High Court, the only way you can add that to the existing certificate would be by way of an additional scope limitation using the hearing non-standard wording and then free typing in an appropriate wording to cover the inherent jurisdiction aspect. If you have a certificate for an application for a secure accommodation order, and then the local authority seek to extend that order, a fresh application for a fresh order needs to be made. So you wouldn't be able to extend or amend the existing certificate. You would have to apply for a fresh certificate. Where you are acting for the child, they qualify for Special Children Act non-means non-merits tested funding. So a fresh SCA application has to be submitted. And where you are acting for a parent or a person with parental responsibility, that has to be submitted as a fresh means and merits tested application, setting out what the parent will bring to the table in terms of the secure accommodation application. Staying with public law applications and the types of alternative proceedings we may see, we are seeing increasing numbers of applications for deprivation of liberty orders being applied for in situations where the threshold for a secure accommodation order has not been met. So again, if those proceedings are being heard within ongoing care proceedings, the existing Special Children Act certificate can be amended, but we do not have a specific wording to cover that. So again, it has to be added by way of an additional scope limitation and free typing in the appropriate wording. However, if the deprivation of liberty application is being timetabled separately from the care proceedings, that will require a separate fresh means and merits tested application, which you can submit under the High Court matter type and select the standard inherent jurisdiction wording where you are seeking or where an application is being made for an order for the welfare of the child. For each fresh application for a deprivation of liberty order, a fresh amendment or application will be required. However, if the local authority is simply applying to extend an existing order which hasn't yet expired, the current certificate can be amended and no separate application is necessary. There is no full representation or version of the special guardianship non-parental party proceeding. So if you need to apply for a certificate at the full representation level of service rather than family help hire in order to cover representing the client at the final hearing, you would have to submit the application as a family help hire one, but again select the non-standard hearing limitation and free type in the relevant wording to cover the final hearing. And that brings us to the end of this presentation, and thank you for your participation.